Thank you. Good morning, everyone. Today is Monday, August the 18th, 2025. This is the regularly scheduled Auctioneer Commission meeting. My name is Roxana Gamusio. I'm the Executive Director with the Auctioneer Commission. I want to welcome everyone that is participating virtually, and our board member Ed Knight is here with us. Also, we have Anna Matlog, Kim Cooper handling our legal portions, and Bob Hunter, who handles all of our licensing. We are starting the meeting promptly at 10:30. I'm going to go ahead and do roll call vote and make sure that if you are participating as a commission member, you can unmute yourself. All of the motions will be done through roll call vote during this meeting. We are able to use Teams for those that can participate virtually for our members as well as the public. And so this is a new change that has been brought forth, and thanks to that, I believe we do have quorum today. Mr. Ed Knight?
Here.
Thank you. Jeff Morris?
Here.
Thank you. And Dwayne Rogers?
Present.
Thank you, members. And we have Jay White that is absent today, but we do have quorum in order to proceed. The first order of business is just informing everyone that this meeting was noticed on the Commission's website since at least May 31st of 2024. Also, this particular agenda was added to the website on August 11th of 2025. If there are any members that join us either in person here or through Teams online that wish to ask questions regarding the agenda or participate in any way, we will make sure to leave meeting time at the end of the meeting with new business to address all those questions. The first order of business is to accept the agenda as it's been presented. It is posted on the website and has been emailed to everyone. I would need a motion to accept the agenda or any changes you have for it.
I'll make a motion.
So moved.
Yeah.
We have a motion by Ed White, and I believe Mr. Dwayne Rogers was the second. Is that correct?
No,
Jeff.
but I will. Dwayne Rogers with a second.
Thank you, Dwayne. All right, by roll call vote to accept the agenda as presented. Ed Knight?
Present.
Thank you. Jeff Morris?
Yes.
And Dwayne Rogers?
Yes.
Thank you. The next order of business is accepting the May minutes. This is May 19th, 2025. Those minutes were also emailed to all of our members. If you see any amendments, please let me know. Otherwise, I will need a motion and a second. And as you read the motion, please say your name for the record. Thank you.
Dwayne Rogers, I'll make that motion, please.
Second.
We have a motion by Dwayne Rogers and a second by Ed Knight. By roll call vote to accept the minutes as presented. Ed Knight?
Yes.
Jeff Morris?
Yes.
And Dwayne Rogers?
Yes.
Thank you. Members, if you're here, on our page 7 is the director's report, and for my two members participating virtually, you have the presentation also in front of you. The financial information that you have is through June of 2025. This is not the final year-end closure. We should have that by October, but it does show that the Commission has a surplus of $10,447 for this fiscal year, and it leaves our reserve at $528,013. The educational fund is at $175,919. I think all those numbers look good. We should end the year with at least a surplus, which will be great. If you have any questions, let me know. This particular piece is informational only. And members, definitely, if you're participating virtually, just let me know if you do have any questions, and I will stop. Before I turn it over to legal, I have two items that came up, and I figure we can have a quick conversation. We didn't have anything on the educational review for this meeting. However, last Thursday, we received documents from TAA, which is the Tennessee Auctioneer Association, regarding their November presentation that they do, and this is the session that they hold each year and that we've been funding. And so by Thursday, we already had the agenda on the website, and all the members had received their documents. Plus, that didn't give us enough time to review the documentation. So I would like for the commission to give me the authority to review these documents, make sure they meet everything that we always have. But I would like on the record approving the funding for the $8,500 since the session is going to take place November 1st through the 3rd. We don't meet again until November the 17th, I believe. And so I would like the commission to motion that I can proceed accepting this so that we fund that session. It is the same amount that we funded last year. The documentation, from what we could see, meets all the requirements. We just didn't have enough time to really review it. And so if the commission is so inclined, I would be approving it with Bob and I reviewing it. And of course, you can give me the authority to do that. If there's any concern, then we would put together an emergency meeting, but I don't see a reason to do that. And so that came through Thursday. Friday, we received from Nashville Auction School a continuing education request for 6 hours, and their session is on September 29th. It would be the same thing. We had a chance to glance at, but not fully review it. And so it meets in line with what they do throughout the different divisions of the state. But if there's a concern, we would do an emergency meeting and make sure to have everyone participate to vote on it. If not, the motion that you would do today would be to approve the funding for TAA for the 8,500 and the continuing education session for both of those events, if there's no concern. And then to add to that, this is something that maybe the commission would want to consider, is giving me the authority to move forward with these educational reviews. I can't think of a time where we've denied one. If it's a brand-new provider, if it's a course that's very different, it may be that I would always bring it to you because it would be different material. But otherwise, just something to think about. Would we be okay with that responsibility coming to the commission, which would be Bob reviewing it, and I'd review it with him and then approve? I welcome any questions that you have regarding this.
This is Jeff Morris. What I would suggest we do, we vote on those individually, just so that you've got clarity on what we're voting on. And so what I would do, I would move first to approve the TAA $8,500 for their educational session. Then we'll take up the other two after we vote on that.
Thank you, Jeff. That sounds fine. So we are reviewing the motion to approve the Tennessee Auctioneer Association. This is the November 1st through 3rd session that they do. It's $8,500 sponsored by the commission, which we've done always in the past. And with that will be the continuing education documentation they've provided. So we have a motion by Jeff Morris. Do we have a second?
Second.
And a second by Ed Knight. Members, any other conversation regarding this particular motion? Okay. Hearing none, to accept that by roll call vote. Ed Knight?
Yes.
Thank you. Jeff Morris?
Yes.
Thank you. And Dwayne Rogers?
Yes.
Thank you. And back to Jeff's point, which is very well taken, it makes sense. Looking at the Nashville Auction School, their session is September 29th, and from what we've been able to see, it matches what they've done in the past. We would need a motion and a second to accept that.
This is Jeff Morris, and I make that motion.
Thank you. Do we have a second?
Second.
And a second by Ed Knight. By roll call vote to approve that continuing education session. Ed Knight? Thank you. Jeff Morris?
Yes.
And Dwayne Rogers?
Yes.
Thank you, members. And then the last question is this something that you want to turn over for us to review within the commission and only bring those of concern or that are new and maybe something that hasn't been discussed before? Are you okay turning that over to us, or is this something that you want to continue reviewing at each meeting?
This is Jeff Morris. What I would suggest is I like the idea that if it's a vendor that we have used consistently and respectfully over the last many years, that you have that, we would grant you that authority to review those and approve those. But that if it is a new vendor, especially an out-of-state vendor, that I think the commission would need to have the right to review those. And I would make that in the form of a motion.
Thank you, Jeff. And I'm going to just reiterate the motion. For for those providers that we've used in the past that have a history with us, that we've approved their sessions, we would move forward with turning that responsibility of review and approval over to the commission. It would be myself approving it. Bob would be the one communicating with them to make sure we have everything. For any new providers or out-of-state information we've not reviewed in the past, those would still come for the commission to do first. And we have a motion for that by Jeff Morris. Do we have a second?
Second.
And a
Dwayne
second.
Rogers will make that second.
Thank you, Dwayne. We have a motion by Jeff Morris and a second by Dwayne Rogers by roll call vote. Ed Knight?
Yes.
Thank you. Jeff Morris?
Yes.
Thank you. And Dwayne Rogers?
Yes.
Thank you, members. I am going to go ahead and turn it over to Ms. Kimberly Cooper here for the legal report, and I'll mute myself. Thank you.
Good morning, members. I'm here to present the legal report for you today. It's a little bit longer than normal, and so if it's all right with you, I'll just take them one by one, and I guess we'll do a motion after each one for approval or another recommendation.
This is Jeff Morris. I'd like to make a suggestion.
Yes, sir.
I've looked at the first 6 items, and they're pretty, the recommendations dismiss all of those. And unless any of the other members really want to go through them one by one, I think the first 6 complaints, 1 through 6, I believe that's correct. The 7th one, I wasn't sure about, but I think items 1 through 6, we would recommend that we dismiss those cases.
Thank you, Jeff. That is a motion to accept the recommendation for complaints 1 through 6. Do we have a second motion?
Dwayne Rogers will make that second motion, please.
Thank you, Dwayne. We have a motion by Jeff Morris, a second by Dwayne Rogers, all by roll call vote. Ed Knight,
Yes.
Jeff Morris,
Yes.
and Dwayne Rogers.
Yes.
Thank you. We are on complaint number 7.
On complaint number 7, it was a complainant that had purchased a vehicle from respondent, or that they said it was the respondent at auction, that had advertised low mileage. The complainant was the winning bidder on that. After the purchase of the vehicle, when they got it home, the complainant obtained a vehicle report, sort of like a Carfax, that showed that the mileage, reported mileage, was much higher than what had been advertised by the respondent. The respondent that this complaint was opened against was not the actual auctioneer, but did know who the actual auctioneer was, and so passed the complaint along to that individual so that they could respond. The actual auctioneer / respondent said that the odometer matched what was reported on the title, and so they didn't have any reason to investigate further. Once the complainant reached out to them, they were sort of dismissed. Their complaint was dismissed by one of the employees, and the respondent, actual auctioneer, did apologize for that and said that they should have investigated further. And they had then reached out to the complainant and offered a refund on the purchase of the truck, and so I recommended dismissal.
In that case, this is Jeff Morris.
Yes,
In that case, it says the respondent said they are not the auctioneer who conducted this particular auction.
Yes, sir.
Who was the auctioneer that conducted the real auction?
It was a family member. They actually own 2 separate auction houses, but they both have the same last name, the principal auctioneers do, of those auction houses. And so when the complaint was opened, it was the complainant who provided the information, and they chose the wrong name. And so when it moved forward, it had to move forward under that name.
Okay, so you finally found the auctioneer who conducted the auction, correct?
Yes, sir. Yes, sir.
Did that auctioneer not verify that mileage on that vehicle before they put it up for auction?
They compared the mileage on the odometer to what was on the title that had been the most recent title that had been updated and submitted to the state, and they were equal or close to being equal. So they didn't feel like they had any, had any reason to investigate further. It wasn't until after the complainant had the vehicle and for a few days and had time to go get one of these Carfaxes, it was the complainant who brought the discrepancy to the attention of the auctioneer.
Did he take the refund or did he keep the car?
As of the time of the respondent submitting their response, they had reached out to the complainant and said, we'll give you a full refund. I don't know, as of the writing of the report, I don't know if they actually took them up on it.
Okay. I'm just real picky about that sort of thing because that's a big deal in our world,
Yes, sir.
getting the facts right. I think I would be okay going along with dismissing it or at least sending a letter of reprimand to make sure that they understand the importance of doing that.
It's not against the actual auctioneer. We have to dismiss it and open a whole new complaint against the actual auctioneer.
What is it? The letter of warning will be against the firm?
It's two different firms. It's not even the same firm.
Okay. You tell them that.
My concern with a letter of warning or a letter of reprimand is that as I said, the complainant submitted the complaint under the wrong licensee.
I got you.
So we would have to open a-
We can dismiss this one. If you wanted to do an administrative open on the other one, we could, I guess, but maybe just wait for that complainant to open it again or advise them if they wanted something done, they need to have the right name.
I can pass that along to the complainant and let them move forward if they want to.
That's the way to handle that. Thank you. I'll make that in the form of a recommendation and a motion.
Yes, sir.
Do we have a second to accept legal counsel's recommendation to dismiss number 7?
Second.
We have a second by Ed Knight. By roll call vote, Jeff Morris,
Yes.
Ed Knight,
Yes.
and Dwayne Rogers.
Yes.
Thank you.
The next two cases, number 8 and 9, are both representations. The first case was an individual that was alleged to have been conducting unlicensed activity. Once they obtained the consent order from council, they did want to be in compliance, and so reached out to the commission to see how they could get their license. It was then discovered that they actually would qualify under the exemption in 62-19103 subsection 12 because they were making less or generating less than $25,000 a year in revenue from the sale of property on online auctions. So my new recommendation would be to dismiss. The case number 9 was administratively opened because that licensee had not, they did a routine audit and found that he was missing a couple of hours of continuing education. He initially did not respond. Once he received the consent order, this individual did respond. They are an out-of-state licensee. They apologized for the confusion and indicated that they thought that through reciprocity, their hours would count, and apparently, I think 2 of the hours did not count. They have since retired their license and have no plans to reactivate that license. So my recommendation would be to close and flag. If this individual does look to take his license out of retirement, he would have to both comply with the continuing education hours and pay the citation that he's already received. And so my recommendation on that would be to close and flag. Do the members have any questions?
This is Jeff Morris. I
Yes, sir.
I agree with your recommendation and I make that in the form of a motion.
Thank you, Mr. Morris. I believe you are motioning to accept legal counsel's recommendation for both numbers 8 and 9. Is that correct?
That is correct.
Thank you. Do we have a second?
Dwayne Rogers will make that second.
Thank you, Dwayne. To accept the recommendations for cases 8 and 9 by roll call vote, Ed Knight.
Yes.
Thank you. Jeff Morris
Yes.
and Dwayne Rogers.
Yes.
Thank you, members. I'm going to turn it over to Anna Matlock to do an annual review that is ready for, as we referred to it, it's the You Are My Sunshine presentation. Anna, it's all yours.
Actually, members, if I could jump back in before turning over to Ms. Matlock, I wanted to remind you all that we did have previously a hearing that was scheduled for this afternoon, a formal hearing. But at the last meeting, you all, we asked for and you gave your approval for the executive director and myself to enter into mediation if all parties were willing. I had not done a mediation before with this particular commission and reached out to the respondent's attorney and myself and the executive director, and we all sat down on July 28th and were able to work it out fairly quickly. So I just wanted to say I appreciate that. It saved not just time and expense for the commission, but for all parties involved. And so I do appreciate that you all gave us that permission to do that. Thank you.
This is Jeff Morris. I am so happy it worked out that way. Those administrative hearings can be long and laborious, and I think it's great that y'all could do it through mediation.
Yes, sir. Thank you.
Well, my presentation is going to be hopefully not long and laborious, but I'll be doing the most talking today. So good morning to everyone. So we are required, I think everyone at this point has sat through public records request, open meetings presentation before. So every year, every other year, we want to give everyone an update to let them know about this information because it's very important. So I'm going to share a PowerPoint with everyone. If you have any questions at any time, please feel free to stop me at that time. So hold on one second. Sorry, everyone. Okay. Commissioner Morris or Commissioner Rogers, can you let me know if you can see that?
Yes, it's loud and clear.
Okay.
I see the slides on the screen.
Fantastic. Okay, so this is the first slide. We're calling this "You Are My Sunshine, My Only Sunshine," because one of the things that we refer to with the Open Meetings Act is that we want to make sure, we're going to talk about this today, transparency, that everything is done in the sunshine. So that's another way that individuals may refer to it as the Sunshine Act. Here's a disclaimer. Essentially what we're saying is this is for informational purposes. It shouldn't be really used outside of this, as like specific legal advice. So everything is going to depend upon specific facts and circumstances if we were to have any of these issues. So this should be given and looked at generally and this is as is, so it may not be everything that you need to know because that would take a very long time. So I'm not going to read through this. But the first thing we're going to talk about is the Public Records Act. So what is exactly included in public records for a board or commission? On the screen, you'll see very generally, I have things such as documents, media, electronic data processing files, and output. But basically, when you're looking at documents, err on the side that it is a public record. There are very few matters that are not considered to be public records. Obviously, certain information is not required to be disclosed. So we're never going to give anyone out your social security number, your driver's license number, none of those things. But as a licensee, your personal information, such as your address or your phone number and email, that is considered to be a public record. All of the documents that you receive for the meetings, those are public records. Our legal reports are public records. The consent orders that we do, once we're completed them and have sent them out, those are considered public records. One of the reasons that we have this is to make sure that it's transparency for individuals that may come and request these public records. Things that are not a public record would be devices in which these documents are displayed. So more specifically, the iPads. If you have a computer, that computer itself is not a public record. Many of the documents are probably, but not the computer. Okay, so that is a brief overview of the Public Records Act. So just a thing to follow up is to keep in mind that the documents are considered to be public records. So if nothing is really considered specifically confidential unless it falls into an exception. So we're going to talk a little bit more about why we do certain things, such as why everyone is blind copied on an email. But certain emails that you send may be considered public records. If you are discussing state business on your cell phone, even if it's your personal cell phone, that can be considered a public record as well. So we want to refrain from doing that. Okay. The next we're going to talk about, and this is going to be the large majority of the presentation, is going to be the Open Meetings Act. So this is how it's going to be structured. We're going to talk about what it is a meeting, what's required for a meeting, and what happens if the board violates the Open Meeting Act. So first off, we're going to give the definition. So essentially, the General Assembly just stated that the policy of this state is for formation of public policy and decisions. They are not to be conducted in secret. So that is the primary reason for open meetings, is we're required to make sure that information is available for the public. We don't want information behind closed doors because that calls for a lack of transparency and also sounds suspect. Almost millennial. Okay, so this portion right here states that nothing in this act should be construed to limit the rights in Article 1, Section 19 of the Constitution. Does anyone know what that is? I'll tell you because no one should. It's related to free speech. So free speech considerations are not limited by the Public Records Act, Open Meetings Act. As I stated before, we are here to promote accountability and openness to protect the public's interest. So when we are discussing the public records and open meetings, it's best to interpret those matters broadly. So if we're asking the question of whether that meeting is to be public or if it's a public record, err on the side of yes as opposed to no. So, as it stated before, all meetings of a governing body, which this commission is a governing body, are to be declared public meetings and open to the public at all times, except as provided by the Constitution of Tennessee. We're going to talk about one circumstance where a public meeting is not required, but again, that's a very small caveat. As I stated before, and this is important when we're discussing things, a governing body means members of the public body that consists of 2 or more members with the authority to make decisions or recommendations. So this applies to all of our boards and commissions. And one of the reasons that we send the materials to everyone beforehand is because if we were to copy 2 or more board members, that could be considered a meeting because we're giving out materials and information. So we're going to talk about this a little bit further, such as a meeting is required this applies to every single meeting. So that means if we have committee meetings, subcommittee meetings, emergency meetings, all of those meetings are included. But it does not include an on-site inspection of any project or program. So that means some of the in-site inspections, so if someone were to come and do an audit of the program, or if someone were to do an audit inspection of public records, that's not considered to be a meeting. And inspectors, in conjunction with the inspection, they're not able to deliberate towards a decision. So if any decision-making is considered, it is going to be a meeting. So this does not include a chance meeting of 2 or more members of a public body. So if Commissioner Knight and Commissioner Morris are both participating in a marathon and they happen to run into each other and have a conversation, that would not be considered a meeting. But if Commissioner Knight and Commissioner Morris were decided to meet each other on Thursday at 10:30 a.m. at a certain location, that is not a chance meeting. Because you planned it in advance. So no chance meetings or informal assemblies can be used to decide or deliberate public business. So if you're having those, you can talk about everything really you should talk about everything but the board business. So these are examples would include a meal together. If you're going to play golf together, some of our boards and commissions, when they come into town, they do have dinner the evening beforehand. It's not my favorite thing in the world. It makes me stressed, but it is not prohibited by the Public Records, by the Open Meetings Act, as long as board business is not decided and we're not taking any votes or decisions at that point. So again, what's not a meeting, we're going to include, that's going to be lunch breaks, restroom breaks, recesses. If we were to have a meeting today and then a public and then a formal hearing tomorrow, anytime we adjourn between two sessions, that is not going to be considered a meeting. Okay, so as I stated before, all meetings are subject to the Open Meetings Act. So that includes regular meetings, special meetings are included. So, excuse me, one of the things that Director Gamusio spoke about during this meeting is if we were to call for an emergency meeting. So an emergency meeting is usually due to a couple of different factors, but it's usually going to be a meeting that's not already noticed on the website. So if we set our meetings out a year in advance, and if it's going to be outside of that, it's either going to be called a special or an emergency meeting, but those are still required to be noticed and available and open to the public. And the one matter that we spoke about before that would not be considered a public meeting is going to be something called executive session. So these are the requirements for executive session. All three of these have to be present together to be considered executive session. So it's one or more board members meet with their board's attorney, and the board is under lawsuit or has been threatened with suit, and the members ask their attorney questions related to such a suit. So this board is familiar with this. We've had a couple of executive sessions related to a couple of our ongoing litigation. And so what I guess the most analogous matter to say for an executive session would be it's a listening session. No decisions are being made during that time. No votes are being made. All conversation is supposed to be initiated from the attorney. So the members are permitted to ask questions, and then I can answer those questions or whoever the attorney is. But the members are really not the ones that are talking. It's the attorneys that are doing the talking and explaining the situation. So it's really a question and answer format. It's given for those very sensitive matters that we want to make sure that the legislature has decided these are not matters that the public is entitled to. So the board may not deliberate about a specific matter before it or potentially before it in any executive session. So again, we're not doing any votes, making any decisions during executive session. That would be something that would be required in a public meeting. So how far does it go? For example, oral interviews were conducted by the Civil Service Commission of Mora County and asking for individuals that were applying for jobs. And so those interviews of those individuals that were going to be considered for those applications would be considered an open meeting. So those cannot be conducted in secret, because those individuals that would be in that particular setting, if the commission is the one that's doing the questions and answering, then those are the persons, they are at that time 2 or more persons making a decision or voting or deliberating. So here's an example of emails. So the chair sends an email that states, here's a news article, or I'd like to add something on the next agenda. That is permitted. What is not permitted is, here's a news item about one of our licensees, we should consider revocation. That email should not be sent to anyone ever. It should be a draft or in your diary, but do not send an email stating that you're looking to take a decision against an individual, because you as an individual cannot do that. Only the board can make those decisions anyway. So if you're going, for example, if you're going to a association meeting or a conference and you're speaking at that conference in your individual capacity. You can speak as an individual, as a member of the board, but you cannot speak for the board as a whole. If someone were to email me and say I have a question about the legal consequences about something that the commission has done, that's fine. I can advise you of that. What cannot happen is I have taken an action as a commissioner and now someone is upset. The person that is upset is me, okay? So I don't ever want to receive an email stating that anyone has taken any actions that the board is permitted to do unilaterally on their own, not in a meeting. I'll talk about the consequences of the things that happen if any of these circumstances were to occur. But essentially, if you have a question and you're asking me or you want to talk about something, generally that is fine. But we're not going to talk about like specific matters such as complaints, specific open active complaints, those types of matters. We're not doing that. So you are permitted to email each other. No, that's a lie. Sorry, I got ahead of myself. So you should not really consider email or call or really send phone conversations to each other, because again, that's not a chance meeting. You're making those decisions you're voluntarily doing that. So it's a volitional act. Chance meetings, it's something that's considered to be involuntary. So even if you're not discussing business and you're just talking about, the score of the Grizzlies game or something like that, it is still going to create the appearance of impropriety. And we don't want that to happen ever and have that caused into scrutiny. So like I was stating before, your public, any text messages specifically related to board business can be considered a public record, just like it could be considered possibly, if you're speaking with another board member, a meeting. So we don't want to do that. So this is a little bit that's talking about what if one or more of the members cannot attend a meeting in person. Very timely. So what will happen is the absent members are permitted to participate electronically, but all votes are roll call votes like we've done so far. And that's so everyone can know who is speaking at that time. And then we must make sure that you're identifiable to the public throughout the meeting by giving your name. So if anyone, because we cannot see you, it is easier to identify persons if you were to say what you've been doing this meeting, which I'm very proud of. Done a great job. So this is the update that is new information that has not been presented before that we are actively using at this moment. So as of July 1st, electronic attendance towards a meeting is not only permitted, but it is allowed to count towards quorum. So it used to be that we were required to have a physical quorum in the building. So if that were to happen in the past, we would not have a quorum from today and we would not be able to meet. However, if we have one person in person and two people virtually participating, that counts as quorum. If we have no persons in person and 3 people on meeting virtually, that also counts as a meeting. So this is good for our boards like this one that are smaller, where quorum is very important, and we're able to meet in different circumstances if someone were unable to attend the meeting. This is also required, so every board is required to have at least one meeting of a physical quorum every 2 calendar years. So we cannot have 2 years worth of meetings exclusively on Microsoft Teams. If we were to do that, we would have to give a report to the Secretary of State and explain what is happening. Also previously during these meetings, if we had to do like a special meeting or these circumstances, we would be required to file a statement of necessity with the Secretary of State's office explaining why that was permitted. We no longer have to do that. any questions related to this? Okay. As I stated earlier, this is what is talking about what is a meeting, so the actual construction of it. It is very broad in general. So it says every meeting where of a governing body except where the statute on its face excludes application. So if everything is considered basically to be a meeting if we're talking about board business and we're deliberating and making decisions. So the application, how that works is that the public has the right to attend, observe, and make comments at our meetings. So we have on our meetings a section for public comment, so individuals are allowed to do that at that time. Also, individuals are allowed to come to our meetings in person or attend electronically. So these are just giving, these two cases are giving examples of how individuals are allowed to participate in the meeting. One caveat I should mention is the Sunshine Law does give the right for individual to participate on meetings and agendas. However, it does not give citizens the right to participate actively in all meetings, nor does it require us to depart from our agenda or to interrupt our business to accommodate the public's demands to be heard. So basically, this is for individuals that come to meetings to disrupt it for any purpose. That is not considered to be a right under the Act. When we ask for individuals that have a public comment, it is supposed to be made towards something specifically on the agenda, but more specifically within the jurisdiction of the board. So if someone is asking for something we can't do anything about, of course we want to limit those conversations. So I'm going to go over this not super in detail, but this is what is required for adequate public notice of a meeting. It must be reasonably noticed, sufficiently detailed, and posted somewhere. So what is reasonable public notice? Well, there's not a specific definition, but a reasonable notice is basically stating enough time for individuals to be able to make the decision whether they would like to attend the meetings. So we post our agendas at least a week in advance on the website so individuals know of it. We set our meeting dates out a year in advance. So individuals are allowed to do that. However, if for some reason we needed to add a fifth meeting, we are not excluded from doing that. We just need to give adequate public notice. One of the good things about the statute is it doesn't have specific concrete parameters. So reasonable public notice, we would like to, if we have to do an emergency meeting, for it to be a couple of days in advance. So if we're going to have one on Wednesday, we want to notice people at least on Monday. So something such as hours or minutes, I do not believe would fall into the example of adequate public notice. So it must be posted sufficiently in advance of the meeting, as I was stating beforehand, so individuals can attend the meeting. And then posted, it must be posted in a location where the community can be aware of such notice. Kim will probably notice that I took one of these off of the slides from the last time I presented it. We have internet and newspaper these are the things that are most used, but we don't post things in the newspaper. And then the third one that I deleted, I can't even remember what it is, but I didn't know what it was, so I took it out. Because, yes. What was it?
Posting of bills.
Bill posting. Posting of bills. I'm showing my age, but it's not on there. But that is permitted. Just not on the slide. So we usually do that on the website, and that's how we notice individuals. So if you're stating here, it is contingent upon the information that's provided, and we put it on the board's website and the department's website. So this kind of goes, I kind of went through this before, determining whether it's public notice is dependent upon all the facts and circumstances. So no one single factor is going to be determined. So we're probably at that point looking at how is it done? What was the reason for the meeting? So a lot of different things go into it to determine whether adequate public notice was given. Okay, this is the big part. So what happens if we were to violate anything related to the Open Meetings Act? The legal effect, we have two different things that are also kind of go hand in hand. First is nullity. So that means anything that was decided in that meeting is null and void. It does not, none of the votes count, none of the decisions made are able to go into effect. Another legal effect can be costs and attorney's fees. So that means if someone were to sue the board because they believe that the matter should be an open meeting and they were to prevail in that lawsuit, then the board would be liable for costs and attorney's fees. I believe something similar like this is occurring in Shelby County related to the school board. So it does happen. So in a nutshell, we want to make sure all board business is accessible to the public. This applies to you as a board member and collectively as a board. We talked about what meetings are. It's a gathering of one or two people. It is not a chance meeting. Chance meetings are those where it's not planned. An exception to this would be the executive sessions, which we talked about, and that's the ability for you to ask questions, but we're not deliberating, deciding. And we have to give public notice. If you violate the law, any violative acts are void, and costs of litigation and attorney's fees may be assessed against the board. So that is in the Open Meetings Act. Does anyone have any questions about anything? Okay, fantastic. The last thing I want to talk to us briefly about is to give us a refresher on North Carolina Dental, North Carolina Board of Dental Examiners versus the Federal Trade Commission. So we talk about this at the very beginning of your orientation. It is a Supreme Court decision that happened in 2015. So essentially, the Board of Dentistry decided to give 47 cease and desist orders to individuals that were doing teeth whitening. The Federal Trade Commission filed a complaint against them, alleging that the board had essentially gone outside of their scope, as teeth whitening was not included in their statute. The board, in return, argued state action immunity. And then ultimately the Federal Trade Association prevailed, which is why we talk about this. So state action immunity is something that this board is familiar with, meaning that you in your official capacity as a board member cannot be, or generally protected from suit if a matter is related to board business. So this is one of the really important reasons why we want to make sure that we're following this, is to keep you immune from, in your personal capacity, from eligibility of suit. That is not what happened to the Board of Dentistry in this case. They were not, federal state immunity was not permitted. So they stated the board did not at that time have active supervision when it interpreted the act and talked about the teeth whitening, when it enforced the cease and desist letters. And so basically we are, just because you're a governmental entity doesn't mean that you get blanket immunity. It is important to make sure that when we're doing these matters that we're not doing anti-competitive practices. So what is active state supervision? We have all of those checks to us today, and it doesn't mean day-to-day involvement of our operations and decisions, but instead it's a reasonable assurance test to make sure that our actors are being supervised and their conduct promotes state policy rather merely the interests of the party's individual interests. So that means essentially that the board as itself, we are, when making these decisions, promoting the overall goal of consumer protection. So our job here is to protect the consumers and the individuals. Our job is not to protect the industry itself specifically. That's what trade associations and those things are for. Our job is to make sure that individuals are not harmed by the actions of the boards and commissions. Some of our other boards have a little bit more difficulty with this. We typically do not have that problem, but that is something to remember in all of the things that we do, is consumer protection. So after the passing of the North Carolina Dental, we established a statute that gives us supervising officials. So who's that official? It is the commissioner or their designee. So in this particular instance, we created the position of a policy director. Our policy director is an individual that watches all of our meetings to see if the decisions that we made may be considered anti-competitive practices. They also look at our rules and those matters. But at the same time, we do have the layer that the attorneys during our meetings, we are looking for through your decisions to make sure it's not something that we might seem as being anti-competitive. So if there's something that like we were to do beforehand, I would just encourage the board at that time for us to have broader discussion. Does this really fall in our jurisdiction? And I mentioned this before when I did this presentation last, that the easiest way to think of North Carolina Dental is to stay in your lane. So do not go into the lane of something that would fall outside of the jurisdiction of the commission. So the supervising official is supposed to make sure that the actions displace competition are consistent with a clearly articulated state policy. So if we're doing something that is going to be that curbs consumer protection or something like that, we have to make sure there's a clear and noticeable state policy on file that would support that. So other than rulemaking, the supervising official can make the decisions of whether what constitutes a potentially unreasonable restraint of trade. So there are certain mechanisms if something were to occur because of the board making an anti-competitive practice. So the board has the ability to review that decision within 10 business days. Usually it is done in the context of an emergency meeting. That would be a meeting where we would talk about the decision and discuss why or why not that decision should be made. Typically, that is the opportunity for the board to overturn the decision because it has been considered to be protective. So that is one ability. However, sorry, I want to go back to this. There is a check. So if the board was super defiant and decided not to do that, then the commissioner of the department does have the ability to veto the decision. And but that has to be written in a report that is given to the General Assembly at the end of each year. So we never want to get to that area, and I don't think that we will, but there are other mechanisms in state law to ensure that you all are protected in the case of litigation, because it would be really not fun if you were sued in your individual capacity, which means you are not entitled to representation by the Attorney General's office. So that means you would have to get your own attorney. Any discipline that were to come from it, such as a civil penalty or something, that's coming from your pocket. That's not coming from the board. So we want to make sure that that does not happen. This ends my presentation. Of course, you have my name and contact information up there, but you should also have it individually. If you have any other questions at any time, of course, you know I'm available to answer those. Thank you so much.
Thank you, Anna. Members, any questions for Anna regarding this topic or anything that it connects?
None for me.
All right. Hearing none, I want to make sure to give us a chance for anyone that is participating virtually. We don't have any members of the public here today. Dana, if you see any hands raised, let me know so that we can give everyone a minute if they have any questions. Okay, hearing
There's
none.
no hands, thank you.
Thank you. I will entertain a motion to adjourn, members, if we don't have anything else.
I would like to add, thank the commission for sending me to the National Auction Association. Very good educational for a changing industry. So thank you guys for doing that.
Thank you for going, Ed. I'm so glad that it went well. I really appreciate that.
I apologize. I have one brief update. I wanted to give the commission about our pending lawsuit. So we did receive notification right now. The second action is in federal court, specifically at the Sixth Circuit Court of Appeals. So last week, we received the decision that the Court of Appeals essentially affirmed the decision from beforehand. So we're still where we are. They believed that the actions of the board were within our purview. What happens next? So the Sixth Circuit, like other circuits, they sit in panels of 3. The plaintiffs in this case would have the ability to request an en banc review, which would mean the full Sixth Circuit would have to listen. And then, of course, there is the ability to submit a writ of certiorari to the Supreme Court for the case to be heard there. So those are the other options that we have related to the case, but as in appeal purposes. So basically what we're going to do is continue what we have been doing, which is regulating online auctions as written in our statutes. Any questions? Fantastic.
Thank you, Anna, for the update. Members, I've got us at 11:25, but I don't want to end if there are any other questions. And if there are none, I will need a motion and a second to adjourn the meeting.
Make a motion to adjourn?
Motion made by
Second.
Ed Knight, thank you, and a second by Jeff Morris by roll call vote. Ed Knight,
Yes.
Jeff Morris,
Yes.
thank you, and Dwayne Rogers.
Yes.
Thank you, members, and thank you for participating virtually so we could conduct the meeting. We are now adjourned.